Nobody expected a Hollywood icon to walk into the Supreme Court and change American law forever, but that's exactly what happened. Denzel Washington, yes, that Denzel, wasn't just there to observe. He was about to take on the Chief Justice of the United States and win. What started as an attempt to embarrass a celebrity turned into one of the most astonishing legal arguments in U.S. history. And the fallout? It shook the very foundation of civil forfeiture law. 3 months before the historic day, a case titled Henderson v. Department of Justice appeared on the Supreme Court docket. It didn't just involve complicated constitutional issues. It involved Denzel Washington filing an amicus brief. Most dismissed it as a publicity stunt. What they didn't know was that Washington had quietly earned a J.D. from Howard University Law School. He had studied law for years between blockbuster film shoots, never telling the world. His journey to a law degree was anything but conventional. Between shooting Oscar-nominated films and red carpet appearances, Denzel pored over constitutional case law late at night. Professors at Howard recall him as one of the most diligent, inquisitive, and humble students they ever taught. He sat through lectures in the back of the classroom, often unrecognized, scribbling notes with the intensity of someone preparing for a courtroom battle he knew would one day arrive. When the court granted Washington a rare 10-minute oral argument slot in support of the petitioner, even seasoned legal analysts scoffed. "This isn't Hollywood," muttered one attorney. "You can't just memorize lines and expect to convince the court." But they were about to find out just how wrong they were. The Supreme Court chamber was packed. As Washington approached the lectern, even the marble walls seemed to tense in anticipation. Chief Justice John Roberts wasted no time. "Mr. Washington," he said with a tone dipped in skepticism, "I find it difficult to believe someone from your background fully understands the constitutional implications of your position." It was a shot across the bow, a clear attempt to rattle him. But Denzel, calm as ever, replied, "Chief Justice Roberts, I believe my argument is consistent with the historical understanding of the Fifth Amendment, but perhaps we should examine the textual and historical evidence together." The gallery went silent. Washington opened a well-worn constitution and several historical documents. This wasn't celebrity grandstanding. It was legal warfare, and Washington had come armed. Those watching closely noted how Roberts, visibly confident in the opening exchange, leaned back slightly when Washington continued unshaken. The tone of the room was changing. Roberts fired back, invoking the 1827 case, the Palmyra, a common trap even experienced lawyers stumble on. Washington didn't blink. He flipped to page 23 of his brief, quoting Justice Story directly. "The Palmyra," he said, "was a maritime piracy case. Not one domestic, land-based forfeiture before 1850 approved seizures like Henderson." He wasn't bluffing. Washington had traced every relevant civil forfeiture ruling from 1789 to 1850. All 27 cases. All involved maritime or customs law. None supported what the government was doing in Philadelphia. The legal observers in the gallery, professors, appellate attorneys, and students, began to murmur. No one had expected this level of detail from a first-time advocate, let alone a Hollywood actor. Justice Alito challenged him with Bennis v. Michigan, where the court upheld forfeiture from an innocent owner. Washington didn't flinch. Respectfully, Bennis was wrongly decided, he said. Justice Thomas and Ginsburg dissented for good reason. And since then, cases like Austin and Timms have clearly moved in a different direction. Washington connected dots few had dared to draw. Civil forfeiture, he argued, had become quasi-criminal and must be treated as such under the Constitution. Kavanaugh pressed him on law enforcement practicality. Washington's reply was sharp. "This is about restoring constitutional balance, not removing legitimate tools." He backed his stance with data. Over 87% of federal civil forfeitures involve no criminal conviction. He argued that these seizures disproportionately affect low-income and minority communities, communities like the one at the center of the Henderson case. Roberts tried again, questioning Washington's use of obscure state cases. That's when Denzel stunned the court. From memory, he detailed the holdings of 8 early state Supreme Court rulings, demonstrating they weren't outliers, but part of a consistent constitutional understanding. Justice Kagan interrupted, impressed. "Did you work with legal historians to prepare this?" "For the historical digging? No, Justice Kagan. That was me. During law school. Nights, weekends, and through archive visits." Gasps echoed in the gallery. The celebrity had just out-researched the legal elite. CNN's Jeffrey Toobin tweeted live, "This isn't just theater. Washington is schooling SCOTUS in real time." As justices leaned forward, Denzel laid out a three-part test. 1. A substantial link between property and crime. 2. Clear proof the owner knew and approved. And 3. Forfeiture must address a specific harm, not just fill government coffers. Justice Barrett dug deeper into his theory about the Fifth Amendment and Due Process Clause. Washington unveiled a Madison letter, never before cited in court, arguing that property rights and due process are inseparable. Justice Thomas broke his usual silence to praise the historical rigor. Even Roberts, who started this hearing with a condescending tone, was now engaging like a student. Law students watching from across the nation live-streamed the session, watching their syllabus come to life. 6 weeks later, the Supreme Court issued a 7-2 ruling siding with Washington's position. Roberts authored the majority opinion himself. In it, he quoted Washington 4 times and even included his three-part test. In a rare footnote, he praised Washington for exceptional historical advocacy. Justice Thomas called for a full reevaluation of forfeiture laws. Sotomayor cited Washington's data to highlight disproportionate harm to marginalized communities. Suddenly, states scrambled to reform their laws. Millions in property was returned. Law enforcement shifted strategy, and civil rights groups hailed the decision as a major victory. The New York Times called it the most significant check on civil forfeiture in half a century. Washington launched a nonprofit, the Washington Justice Initiative. Law schools invited him to guest lecture. Bar associations lined up for his keynote. Legal blogs dissected his performance. Roberts even joined him at a Georgetown forum months later. There, Roberts admitted, "Mr. Washington taught me a valuable lesson. Never confuse celebrity with capability." Denzel responded, "In court, like on stage, the work speaks. I'm just glad the Constitution got a voice that day." This wasn't just a courtroom drama. It was a moment where merit defeated assumptions, where one man's preparation, grit, and belief in justice changed American law and reminded the world that brilliance often comes from the most unexpected places. If you were inspired by this extraordinary showdown, don't forget to like, share, and subscribe. Let us know in the comments. Should more professionals from outside traditional backgrounds step into legal and political spaces? What would you have done if you were in Denzel's shoes? We'll see you in the next story, where the truth hits harder than fiction.